Welcome to Module 7's mini-teach session on Jones vs. Alfred H. Mayer's Company by Dakota Sky Slattery. Now, the litigants in this case are Mr. Jones, who is an African-American man, who approached the second litigant in the case, a real estate company in St. Louisiana County of Missouri, which had refused to sell him a home based upon his race and skin color. The law or constitutional provision at hand in this issue is Federal Statute 42 U.S.C. Section 1982. This statute grants equal rights for every citizen regardless of their race or skin color, so they can make a real estate transaction. The facts of this case go back in 1968, where the man, Jones, the African American, had filed a lawsuit against the real estate company in Missouri, St. Louis County, had refused to sell him a home in the certain neighborhood he'd been hoping to live in just because of his race and skin color. So basically, this real estate company in the Eastern District of Missouri refused to sell a home to Mr. Jones, mainly based on his skin color. This is in violation of the said constitutional provision of Federal Statute 42 U.S.C. Section 1982, which prevents this whole ordeal where an American man was denied real estate transaction based on his skin color and race. Now, the issues in this case are that the defendant had violated the civil rights of Mr. Jones, which are Federal State Statute 42 U.S.C. Section 1982, and as you all know, guarantees the rights of every citizen trying to make real estate transactions. Now, does anyone have the right to deny the business transaction of anyone just because of their skin or race color? No, they do not have the right to do that. And does federal state statute truly grant a person the right to conduct business transactions just like everyone else? Yes, the federal statute does indeed grant people the equal protection rights to conduct any form of transaction, such as this real estate purchase. Now, the holding and rationale behind this case. The decision of this case was in a 7-2 decision for Mr. Jones, where the court had ruled that the federal statute, not the Sparrow statute, barred all forms of racial discrimination by private owners as well as public authorities in the sale or retail of any property, such as how Mr. Alfred H. Mayer's company had denied Mr. Jones the ability to have a real estate transaction. The opinions of the court are that that they sided with Mr. Jones and upheld that the Civil Rights section of 1982 of the Congressional Act is indeed correct, and it's intended to prohibit all forms of discrimination against people of a different race in the sale or realty of properties, which includes government as well as private discrimination. And I myself concur in the majority opinion by Potter Stewart that the civil rights statute, such as Section 1982, which prohibits all racial discrimination in business transactions, especially real estate or property transactions, should be indeed upheld. Now, the significance of this case are that it allowed the Civil Rights Act of 1968 to be born, allowing the federal government to ban any private properties from engaging any form of discriminatory housing policies. Basically, it's stopping people like Alfred H. Mayer's company from performing discriminatory housing policies against people like Mr. Jones or anyone else who's of a different race and skin color, from buying properties to business property to housing, and is showing a clear and definite break stop from people openly discriminating to others based on their skin, race, from buying any form of property. There are many cases like this all across America where people won't do business with others based on their skin color or race. And this is just many of the cases that were resolved in the betterment of those people getting the rights they need to conduct business just like everyone else. Thank you for your time. The end.